Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you, everyone. Please be seated. Can't help but notice that we have 4 women counsel today. Welcome, says the female chief judge. We are here today for the submission of Harding versus Sasso without oral argument. It is hereby submitted. And the same is true for the case of Hagen versus Serta. Both of those cases are submitted to the court without oral argument. This afternoon, we are going to hear the case of White versus State of Iowa. It looks like the parties are ready, and it's my understanding Alexa Den Herder is going to argue. Thank you. You may proceed.
May it please the court, counsel, Alexa Den Herder on behalf of the State of Iowa and the Iowa Department of Health and Human Services. The main issue before this court today is the admissibility of Me Too evidence in a sexual harassment case. Me Too evidence is evidence of discrimination or harassment against people other than the plaintiff. This type of evidence is not per se admissible or inadmissible, but must be tailored to the facts and theory of a plaintiff's case. In this case, Tracy White sued the state, her employer, alleging sexual harassment. Before trial, the state moved in limine to exclude certain Me Too evidence from being introduced. The district court denied the motion in full without weighing the evidence or applying the so-called Me Too factors, treating the evidence as per se admissible. As a result, yes, Your Honor.
A written ruling from the court, but I see a court reporter memorandum that shortly before trial there was a hearing on pending motions. Was that hearing reported?
Not reported, but trial counsel believes that the motion was denied in full, therefore preserving the motion in limine in full, preserving error in full before trial.
I mean, you're the appellant, it's your burden. I realize you weren't trial counsel, but it's a problem for us if we don't get to read the ruling to see if it was final or if there's any equivocation.
That's why trial counsel, out of abundance of caution, re-raised the matter at the beginning of trial. She lodged a standing objection to the topics preserved in the motion in limine, and the trial judge acknowledged that the standing objections were acknowledged without.
Looked like he's acknowledging on certain exhibits a standing objection at the time the exhibits are offered, but it didn't seem to be quite as clear as your reply brief would suggest.
Look at page 8 of the May 5th trial, about line 20. Trial counsel says, and we believe as set forth in detail in our motion in limine, that these topics are not relevant to the instant matter and should be excluded. And the trial judge acknowledged that as a standing objection and said it'd be acknowledged without the need for further objection throughout trial when any of the topics were raised.
Correct. Well, yeah, first, could you repeat that page number?
8 of the May 5th and 6th document.
B.
Sorry, I don't have that on hand. I apologize. But I do have it. It is line 20 of the, I think it's the first day of trial.
When you read that in context on line 9, it says, Your Honor, we would just like to note our continuing standing objection to exhibits that reference materials. And then it goes on and talks about the topics in the exhibits. That's how I read that. Tell me why that's wrong.
Overlap also between the topics and the contents of the exhibits and the testimony. I believe that to object any further to the topics in the testimony would have been purely theater and unrequired to preserve error.
We're talking about rules of evidence. You don't object to topics. You object to the admission of testimony and you object to the admission of exhibits. So when somebody says, I want a standing objection to exhibits, I mean, I interpret that to mean you're objecting to exhibits.
Our motion in limine addressed evidence, which includes exhibits and topics and testimony. It includes all of those. It's evidence in general. And so when counsel said that, unfortunately, there is no ruling, Your Honor, but I believe that trial counsel believed, she said here at the beginning that the motion in limine was overruled and the district judge did not seem to contest that. He did not say that the evidence was open for reconsideration, and I think that had he would have asked counsel for further objections, but he seemed to, it seemed to be that the evidence was coming in here, and that's why counsel took, out of abundance of caution, raised the standing objection.
I understand correctly that the standing objection was not repeated each time a new witness came in?
Your Honor, because the district court told her that she did not need to re-object every time the exhibits were mentioned or any of the topics were mentioned. He said here, any standing objections will be allowed, and therefore the court will recognize them at the time they are introduced or presented or talked about. That would mean that she would not need to re-object at that time.
Like they're talking about exhibits, not testimony, because I'm reading page after page of witness testimony about what happened to other people without any objection, and that handicaps our review without an objection and a colloquy on why that particular witness account of what happened to somebody else is relevant or is not more prejudicial than probative.
Say that she will not need to make an objection at that time, and the record should reflect that you are not waiving any objections to the ones that you have standing objections to. And he granted that standing objection at the very beginning of trial, and so for her to re-object to evidence that was already coming in would have been theatrical. And so the trial counsel did not believe that she needed to re-object when he said to her specifically that that the record should reflect you are not waiving any objections to the ones you have any standing objections to. And with that, I would like to ask the court today for 3 forms of relief. First, the state asked the court for a new trial. The uncurbed admission of the Me Too evidence in this case resulted in a verdict from passion and prejudice warranting this relief. This court should affirmatively adopt the Me Too factors it embraced earlier this year in Valadez, apply them to the evidence at issue, and remand for a new trial. Second, and alternatively, the state asked the court to grant its motion for a directed verdict. After excluding the prejudicial Me Too evidence, the remaining evidence of harassment against Ms. White does not rise to the legal standard of severe or pervasive, which is required to sustain a hostile work environment claim. First, I want to address why a new trial is warranted here. There are 4 categories of evidence admitted at this trial that are at issue. The first category is conduct that White did not know about until trial. The second category is conduct that was reported to White in her capacity as a supervisor. The third category is conduct concerning race and homophobia. And the fourth category is conduct White overheard that was directed at her. The state does not contest the admissibility of the fourth category of evidence.
Seeking a new trial on grounds that the jury instruction was erroneous.
Instruction has it misstates the law. It specifies that the jury could consider harassment, which Tracy White was unaware of in determining intent. And in that case, the jury could look and say, oh, well, Darcy Patterson intended to harass Darcy Patterson to Jen Jackson, and that has nothing to do with Tracy White or her claim for sexual harassment herself.
The sentence in there that the state objected to is language that's not found in the Eighth Circuit pattern instruction, correct?
We also objected and said that any of the conduct needed to, pattern or practice needed to be directed at Tracy White herself. And unfortunately, this is also not a pattern or practice claim. That comes under a different section of ICRA.
That the jury instruction given on that issue is erroneous.
Looking at Madison versus IBP, which is the jury instruction that is cited, that says that it needs to be a pattern or part of a pattern or practice towards the plaintiff, towards her. And here the jury was left to consider practices of harassment towards other people, many of which were testified at trial in length about things that Ms. White wasn't aware of or reports that she received in her capacity as a supervisor. And so I want to talk about the evidence that Ms. White was...
I mean, this is a hostile work environment issue, right? And so don't we need to have sort of the totality of the facts about what's going on to get a sense of that environment?
Of the circumstances analysis, but it's a totality of the circumstances analysis for Ms. White's environment. And things that are happening that Ms. White just wasn't aware of until trial can't possibly be a part of her environment. A plaintiff can't be harassed by something that she did not experience. And a reasonable person in the plaintiff's position is not one who knows or learns about what happened only after discovery and only after trial. And that's what happened here. The jury heard hours, if not a day's worth of testimony about Darcy Patterson's conduct towards Jen Jackson that Ms. White had no idea about until trial. It was sexually explicit. It talked about sex toys and the like, and it also talked about physical assault, which is something that Ms. White herself did not experience. And that, was highly, yep.
Evidence. So what is the testimony about the evidence that was presented to Ms. White that was complaining about Darcy?
I understand from the record that the evidence that was presented to Ms. White about Darcy was that Darcy was a menace and she was a negative supervisor to have. Ms. White did not.
Complaining to, this is part of your discussion of the evidence that was complaints to Ms. White as a supervisor, is that?
That is correct. That is also a category of evidence, of course. But it is our position that reports of harassment can't possibly be harassment. We need to encourage, that goes against the remedial purpose of ICRA. We need to encourage people to employees to report early and to report often. And quite frankly, employers will be held duly liable if every time a supervisor receives a report of complaint, they too are harassed. And so the daddy comment, the nectar of the gods comment, and the eye candy comment could not have possibly harassed Ms. White because they were reports of harassment. And as a second point, harassment needs to be unwelcome in order for it to be a part of a hostile.
What was complaints about Darcy that were made to Tracy White, could that factor into her hostile work environment if she reported and nothing happened?
Because the conduct that Jen Jackson reported to Tracy White was that Darcy Patterson was a hard boss. She was a bad boss. Ms. White didn't learn the extent of the sexual nature of that relationship until trial. She only knew about that, and she said she didn't press, Jen Jackson on that because of, she was trained in trauma practices, but she didn't learn about the sexual harassment until much later, and most of it at trial. And to circle back to the reports of...
I don't quite follow the distinction between whether it was a report. As long as Ms. White was aware of it, I mean, for example, I have a daughter who's Jewish who's attending a university and is one of those people who's feeling somewhat threatened by some of the statements that are going on. And I don't think it would make a difference to her whether whether it was reported to the administration or whether it happened in front of her. Either way, it contributes to the environment that she would feel. I mean, why is that different?
2 points to that, Your Honor. Reports of harassment, reports of harassment cannot be unwelcome harassment, and that's one of the factors of a hostile work environment claim is that harassment has to be unwelcome, and we cannot say that reports.
Has to be some unwelcome harassment, which there was here. I mean, even the state doesn't dispute that. But then in considering the overall environment, why can't you consider other things that were known to Ms. White at the time?
The reports of harassment and the evidence, surrounding them came in at trial, and the jury heard them, and they heard sexually explicit and inflammatory reports to Ms. White, and that shouldn't have been used because they were reports of harassment, and Ms. White can't in turn be harassed by a report of harassment.
Based on that, I kind of get it's a fine distinction, but the idea is that she's claiming, and I think that in the red briefs, they talk about that kind of the state's missing the argument. The argument is that her failure, she was not able to protect her subordinates. So what's your best authority to say that a supervisor who is informed of this hostile work environment that her subordinates are being subject to, but then nothing's happening? Is there some case that makes that distinction or that can support that?
I would have for that would be the ones that list the factors for hostile work environment claim, and it's that second factor, it's unwelcome harassment and just reports of harassment. Our position is that they cannot be unwelcome, and we have to remember that this is a sexual harassment claim towards Ms. White, and so she's not being sexually harassed by reports of harassment, and that would be the position of the state.
About the admissibility of this evidence and maybe limiting instruction. So it seems to me that the federal circuits that have considered this issue say evidence of harassment of which the plaintiff was unaware cannot be admitted for the purposes of establishing pervasiveness, the objective prong of the jury instruction. And if you admit that kind of evidence, well, let me back up. But it could be admitted for the purposes of proving intent, which would be a different element, that the harassment was motivated by her sex. Do you disagree with that as a statement of the law? Because as I look at it, at least the 11th, the 8th, the 10th, the 9th, the 6th, the 7th, the 3rd, the 4th have all made this distinction, and they've talked about limiting instructions.
It can't go to the reasonable person test to show that a work environment is hostile, the evidence that the plaintiff is unaware of. But yeah, it can go to show intent. It can go to show motive, knowledge. It can be used in rebuttal. It can be.
It's true. And your objection here was just kind of a general relevancy objection. And you didn't make these specific distinctions. When I say you, I mean, I understand you weren't trial counsel. But the state didn't make these distinctions in the district court saying, Your Honor, we think it's irrelevant for the purposes of establishing objective pervasiveness. We would request a limiting instruction. We understand it could be for intent. How are we supposed to evaluate that if it was properly admitted for one purpose and you didn't make the right objections or request the right limiting instructions?
Points on that, Your Honor. First, I think the motion in limine was pretty explicit about why the evidence was being excluded, why we asked for it to be excluded, and that it wasn't being used to show intent or motive or knowledge. It was being used to show the hostile work environment, that Ms. White's environment was hostile. Second, I would say the way.
A request for a limiting instruction? Okay.
A limiting instruction. And second, I would say that that's not how the evidence was used here. The evidence wasn't used in rebuttal. The evidence wasn't used to show intent or knowledge. The evidence was highly inflammatory, and it was used to show that Ms. White's work environment was hostile. And that's what the jury was listened to, and that's what influenced the jury. And I want to talk quickly about the yes.
And a half over, but you get, no, I know everybody gets confused. The clock's going up now. People think, oh, I still have a little bit of time. You get to come back.
Appreciate it.
That clock work.
Good afternoon, Your Honors. Thank you. First of all, motions in limine, rulings on motions in limine don't preserve error. I was there, and I don't recall a standing objection other than the ones that the defendant stated on the record. I certainly don't recall Judge Rosenberg stating that it was never going to be revisited and we're not going to talk about this again or anything like that to indicate that his ruling was final. But even if the state would have had a standing objection to the exhibits in question or even to the testimony in question, they can't act inconsistently with that, which they did repeatedly. When the judge asks if you object to a particular exhibit and you say, no, Your Honor, no objection, that doesn't preserve your error. It doesn't tell the judge that this is part of what I was objecting to earlier. You certainly don't.
I'm looking at a court reporter memorandum that says there was a reporter at this May 4 hearing on pending motions. Now, it doesn't say what motions they were, but it's right before trial and right after the motions in limine were fully briefed. Was there a reporter there when the judge orally announced his ruling on the motions in limine?
Your Honor, generally we have a reporter there for things like that. I can't tell you what happened. I know that this appeal was delayed in long part because there were some court reporter issues. So I can't tell you the answer to that. You certainly don't get to stipulate to entry of exhibits that you're later going to object to, like the defendants did for those terrible photos in Darcy Patterson's office that had the penis candles and the sexual lubricant and everything like that. They stipulated on the record to entry of that exhibit. And you don't get to preserve error at the same time you're actually introducing yourself exhibits that discuss these things, which would have violated the motion in limine, which the defendants did. And we list them on page 37 of our brief.
Isn't the argument coming back if they're coming in, then the state gets to use them to sort of take sting out, right? That they get to introduce them and actually use them once they know that they're coming in.
Not that I know of, Your Honor. If you are objecting to certain evidence, I think you have to be consistent with that throughout the trial and to actually affirmative, I mean, these were on their exhibit list from the beginning, and they affirmatively introduced them and affirmatively said they didn't have objections to ours. Even if this court were to find that the defendant's failure to preserve error is excused somehow, the defendants still lose because the sexual conduct or sexist conduct at issue affected the plaintiff's work environment. There's a difference between conduct of which the plaintiff is oblivious and conduct which she knows about during her employment and which affected her emotionally. Conduct that she doesn't know about is irrelevant to damages and irrelevant to whether or not it was severe or pervasive.
Is that even irrelevant to intent? I mean, the argument you make is you can use that for intent, but then the question, then you say, well, whose intent? McEnroy? Well, I think you had plenty of evidence of his intent. You didn't need things that she wasn't aware of to show that. So whose intent did you need it for?
Whoever that might be. And it's to prove intent in the
that was directly harassing her was McEnroe, and then excuse me, and then the other things contributed to the environment, but those weren't people who were actively directing harassment toward Ms. White, were they?
The intent that we're talking about is motive. It's the protected class.
That is relevant. I see intent would be intent of the harasser plus the environment. The environment is the environment. I mean, you don't need other evidence of, you don't need intent evidence for environment evidence that doesn't relate to the person that was her boss.
There's a lot of case law that says such evidence is admissible for the purposes of intent, for the purposes of notice, for the purpose of whether or not the defendants took prompt and appropriate action. Okay.
Precision, and that's why I'm trying to get to that a little bit. Thanks.
What it comes down to, though, is none, absolutely zero, of the evidence that Tracy White did not personally know about during her employment was admitted, except that the defendants introduced it or they affirmatively said they didn't object. They did not preserve error as to any of that evidence. In fact, it's ironic that they objected to instruction number 16 because instruction number 16 really is the limiting instruction that you were talking about. It says, you've heard this evidence about conduct that Tracy wasn't aware of. You can only use it for this limited purpose. It may not have been.
I mean, that's why, if I was a defendant, I wouldn't like that either, because it says you may consider it for, and there's a list of about 5 things, but it doesn't, actually say you can't consider it for other purposes, and that's the problem.
That instruction says that you can consider only conduct that she was aware of in deciding whether it was severe or pervasive or deciding damages.
If we got past error preservation or reversed on the instructional alleged error and wanted to give some guidance for issues likely to recur on remand, how is discussion of harassment directed at others as to race or sexual orientation admissible as to whether she was a victim of sex discrimination?
That's a great question, and the answer is, especially with race, very little. I think that some of the evidence about those 2 topics at trial was very minimal, and I think that it is admissible somewhat to show that the defendants who touted their policies about harassment as being so good, that they weren't enforcing those policies. Part of it was almost unavoidable in the sense that many of these complaints were discussed in the same breath. And for instance, the defendants introduced all these transcripts of the state's investigation into Tracy's complaints at one point. And those transcripts where she mentions, I think this person was mistreated on the basis of race. The sexual orientation stuff is a little bit closer question because, I mean, one of the things Mike McEnroy used to routinely talk about is how gross it was to consider the image of these two women in the office having sex together. One of the biggest mistakes that defendants are making, and I really urge you to look at this issue closely, is they're mislabeling what Me Too evidence is. And they're mislabeling the standards for which this evidence is admitted in a sexual harassment case. Me Too evidence is evidence of discrimination against other people in the plaintiff's protected class. And it's admissible as circumstantial evidence that the defendant's motive in the way they treated her was also their protected class. It has all sorts of requirements about that the employees be similarly situated. None of that applies here. As some of the justices have recognized, sexual harassment cases are fundamentally different. And as long as conduct was infecting the plaintiff's work environment, it doesn't matter if it was directed to her, it doesn't matter if it was directed toward someone else in her protected class, it doesn't matter if it was directed at no one. Guys sitting around, yes.
They're similar on the issue of a supervisor type situation. So there's sexual harassment, maybe to subordinates who are complaining to a supervisor. And so the supervisor herself is not being harassed and maybe isn't even part of that hostile environment, but still has an ICRA type claim because nothing is happening to protect her subordinates.
Law on point regarding that. But I will say that the state's argument on that point is somewhat hyperbolic. It's not the reports that were the problem. Tracy did not get traumatized by hearing employees complain to her necessarily. What was distressing was the conduct itself. What was distressing is that she complained and complained and complained and believed that the state would do something about what all these people were experiencing, and which was seeping over into her own work environment, and nothing was done.
It's a really fine distinction, but I think that it is an important one that that we're careful that we understand what ICRA is covering, and it's protecting employees from hostile environments, the harassment of Tracy White as the plaintiff, and so. I mean, it seems like a really broad expansion if we're going to say, well, this person wasn't necessarily, her environment might not have been hostile, but she was really upset because the environment of other people under her was, and no one was doing anything about it.
I think that the defendants made that argument at trial, and the jury rejected that argument. I think the jury found that this was all part of Tracy's.
Does this kind of come up in part of the instruction number 16, where they argued about the difference in the Madison case, that it said that it had to be a pattern in practice against her, meaning the plaintiff, and here it just said it can be show the pattern in practice, but we don't know who it's against.
Object to that instruction because it included those words. They said this is an incorrect statement of the law, and that's all they said about it.
The whole last sentence, right?
The last sentence is an incorrect statement of the law. They did not tell the trial judge why it was an incorrect statement of the law or that those two words weren't in the other instruction. I don't think that was a specific enough objection to alert the trial judge as to their problem with it.
Heard about why? Do you think that it was error?
Made a record about why. I might have said fine. I thought it was important.
I just want to know if this is an erroneous instruction or not, that last sentence.
It's an erroneous instruction.
Not an erroneous instruction.
It is almost verbatim the instruction that the 8th Circuit approved in Madison.
Words are kind of important.
If the defendants had objected to the last two words, we could have taken out those last two words.
Adam, I mean, that's the problem was that the last two words were not there. And so the instruction said, was just a pattern or practice, period.
Instruction, but I know that was some authority for it. The focus, I think this court held in Valdez, is supposed to be on the way that the employer reacted to the harassment and not necessarily on the acts of harassment itself. And with respect to the acts against others, most of them were not against any particular person. And in a harassment case, it's so fact-driven. It's really hard to say, like, let's say we're taking this meeting where everybody's kind of making fun of this woman who's wearing this short, tight red dress at work. And is that harassment against this woman who's not there? Is it harassment against all women? I can tell you Tracy personally felt horribly uncomfortable and distressed that this was happening, in her workplace.
The group of testimony or evidence about the facts that she was not aware of when she was employed?
Most importantly, I think instruction number 16, it doesn't have to be perfect. Instructions can be generally the right, the gist of them can be correct. I think defendants would have had a valid objection maybe to some of this evidence if they had objected, and if that instruction had not been given, because I think it limited the jury. It was important to me to preserve to preserve my record, that we had an instruction like this to tell the jury, you can't use it to help Tracy White and say her environment was like this, or that I get damages for this because somebody grabbed somebody's breast. She wasn't requesting damages for that, and we made that very clear to the jury, that this, and case law says it's relevant. In our case, in particular, it was relevant to show the defendant's utter failure to take prompt and effective remedial action.
Since you mentioned damages, could you just touch briefly on why the future damages that are twice as much as the prior damages is not extraordinary?
Assessing damages is uniquely a jury function. Our system is designed to entrust these important decisions to members of the community. With all due respect, Your Honors, you are more insular and you are more alike than people.
More specific to the idea that the prior damages, they're both emotional distress type damages, as I understand. She got $260,000 or whatever for prior, which would have been up to the time of trial, and by that time she had she's still in the same job, new supervisor, things are so much better, yet her futures are twice what the priors were.
We picked that number. I can tell you that her therapist had very persuasive testimony and vivid testimony about the changes to Tracy's brain that took place because of what she had been through, that her amygdala was like on a red alert and was causing her to interpret things just in her regular life in a different way, of kind of a fight or flight response. She said that this was likely permanent. I apologize, she didn't say it was likely permanent. She said it could be permanent. We don't know how long it could last. I think that if the jury was instructed that Tracy would likely live for 28 more years from a mortality table. And if you take that award for future emotional distress, it comes out to less than $19,000 a year. That's not an outrageous amount for the kind of harm that we're talking about that would go on for the rest of her life if the jury believed that. Thank you, Your Honors.
Thank you, Your Honor. I'd like just to touch on a few points. I'd like to start with my fourth category of evidence, which had to do with Mike McEnroy and comments that he's a racist and that he's a homophobe. Those are highly prejudicial and of minimal probative value, and the jury heard about both of them. It's propensity evidence. It's not allowed, and I think that it was highly prejudicial to the jury, and more likely that they want to punish DHS for issues that DHS was not on trial for. I also want to touch on damages. I can tell you why the jury gave an award over $500,000. It's because of the inflammatory evidence it heard about.
On this, I mean, maybe I'm, just fell off the turnip truck, but I mean, it strikes me when you encounter people that are sort of misogynistic, they also sometimes make homophobic comments about gay women, particularly, and the two things are kind of merged together. I mean, and why couldn't that have been presented to the jury that way?
Sexual orientation is a separate claim, and it's confusing to the jury. The jury all of a sudden is unclear about what they're looking at. Is it sexual harassment? Is it discrimination based on sexual orientation? I think at most it's very confusing to the jury as to what DHS is on trial for. And
What inflammatory evidence came in that she was unaware of, that might go to whether the jury instruction, if erroneous, was prejudicial?
I think that at the end of trial, Ms. White said she was unaware of everything that Jen Jackson said. And there's a long excerpt about what those things are. They're very explicit, and they're very inappropriate. I don't feel the need to recite them here, but they were highly inflammatory, and certainly a jury would look at that and say, we want to punish DHS, but they don't need to punish DHS twice. This is not Jen Jackson's trial. This is Ms. White's trial. And so that inflammatory evidence is what should have been excluded, but unfortunately it was not. And that's also what led to this very excessive jury verdict, unjustified jury verdict of...
I turn you back to instruction 16. So when we earlier talked about kind of circuit courts and their law on limiting instructions and how you use this kind of evidence in the workplace, I guess it didn't register until Ms. Fiedler had indicated it. It does look like the first part of that sentence is the limiting instruction. It says that this other evidence of conduct toward others doesn't go to the severe and pervasiveness prong, but you can use it for other purposes. Tell me why that's incorrect.
The intent part, Your Honor.
The entire instruction. I mean, I'm sitting here looking at circuit court cases that look exactly like this jury instruction.
Juries read instructions in full, and they consider, the first part of that, and they consider the last sentence, together. And so the misstatement of the law in the last sentence tainted the entire jury instruction.
Counsel made a point about the objection that was made here, and I'm reading it right now, and it does seem to be a fairly minimal objection, incorrect statement of the law, and I'm just struggling to see, as a district court judge, how they might have viewed it.
Trial counsel did object to the entire last sentence of the jury instruction. I think that's important. And there's multiple misstatements of the law in there, whether it goes to intent or whether it goes to the pattern or practice sentence. Both are, misstatements of the law. And
Words on the pattern of practice against her. So two important words, but was the objection specific enough to alert the trial court that, hey, maybe that's a mistake and I should correct it?
there are so many issues with the last sentence of the jury instruction that it does put the trial court on notice that the jury instruction was faulty, especially that last sentence.
So many issues. Tell me what those issues are.
Part which goes to intent, you can consider anything, even things that Ms. White was unaware of in determining intent. That's so vague and so broad that a jury doesn't know what they're actually looking at. Whose intent was it? It could have been DHS's, it could have been Mike McEnroy's, it could have been Darcy Patterson's. And so that's, of course, itself is confusing for the jury. And then, of course, the pattern or practice part was, first of all, again, this is not a pattern or practice claim. That's a completely different part of the Iowa Code. And again, it had to have been towards Ms. White herself, not towards anybody else. And the jury wasn't given a fair chance to.
If you think intent was wrong or not sufficiently defined, under our rules, isn't it trial counsel's obligation to offer alternative language and an alternative instruction? And if there's no alternative language presented to the poor district court judge, what is he supposed to do?
Did her job when she objected to that last sentence of the jury instruction, put.
Wasn't she supposed to propose some language that the judge could actually use in an instruction? It's not the judge's job necessarily to divine her intent when she says, I object. I mean, he says this is a correct statement of the law, generally speaking. If you think it's insufficiently specific, then doesn't trial counsel have an obligation to provide the specifics?
I was not trial counsel, but I believe that, trial counsel did her best when she objected to that last line of the jury instruction and preserved it for error for us to talk about today.
Earlier, you said on your point about the directed verdict that if the Me Too evidence was excluded, you would have been entitled to directed verdict. Does that argument turn on us agreeing that that other evidence should have been excluded?
Evidence is so minimally probative of Ms. White's claim that even if it stays in, even if you consider it in the totality of the evidence here, no, it's still not enough, because at the end of the day, the things that Ms. White experienced is a handful of comments over a long period of time, only one of which was directed towards her. Certainly doesn't rise to the level of severe and pervasive.
They're not yours. Okay, thank you.
Thank you.
White versus State of Iowa is hereby submitted, and court is adjourned for the afternoon.